You may now be seated.
Yes, sir.
Please court, Your Honor, before the jury brought in, I have a matter of law I'd like to deal with.
Yes, sir.
Your Honor, we've been informed by the Attorney General has been very accommodating. He's telling him who he's going to call this afternoon or this morning. One of the witnesses would be Brett Dove, and Brett Dove, I think they'll agree, is the person that did receive the extract from, you heard the Secret Service agent this morning, and did some analysis on it. I'd like to show the court. Is this working? Can I have the Elmo on, please? State's Exhibit number 299. Where can I see that? Let me see it online. Okay, and this is, wait, just let me have you push it up in just a minute. You don't need to. That's a receipt of property for Paul Murdaugh's phone, and if you'll slide the thing down a little bit, no, the other way, you'll see that Bobby, what's his last name, Bancroft, received it from David Owens, who gave it to Bobby Bancroft, who then gave it to who? R. Kelly. Right. And then Paul McGonigal, we heard from this morning, gave it to, he was at the Charleston Sheriff's Office, gave it to, whose name is that? Looks like Brian Heddick, who gave it to, well, it got to Brian Heddick at Computer Crimes, I guess by Ryan Kelly. The point I'm trying to make, Judge, let me show you the second page, is there are a number of people in the chain of custody on this phone who haven't testified yet. As a result, if Mr. Dove is allowed to testify about the contents of the phone, which he received from Secret Service, we believe that breaks, that would not complete the chain of custody. All we're saying is call these other people, and I mean, they're not going to be long witnesses, to complete the chain, to authenticate that what exactly came out of that phone was the phone that was found at the scene on Paul Murdaugh's body. I don't know if this is complicated or not, but it seems to me that they ought to have to do that.
Mr. Waters.
Thank you, Your Honor. Just very quickly, as we look at the chain on and I'll take those, thank you, on Paul's phone, again, Mr. Conrad is going to call Lieutenant Dove here in a bit. We've had testimony from Jason Chapman about David Owen securing that phone. We've had introduction into evidence, Your Honor, without objection of both of these chain sheets. There was no qualification or objection to the information on these chain sheets, no hearsay objection or anything like that on both of these, which carried the chain all the way through. And then, of course, but we have testimony about the collection of that phone. We have testimony from multiple witnesses about the manner in which agents secure phones and the rest of that. And then we have testimony about that phone going essentially through a couple of couriers to Paul McGonigal, who just testified as to his involvement with that phone, as well as to his delivery of that back to Lieutenant Dove. And then you've had testimony from Agent Van Houten, who received that phone and analyzed it and then delivered that back to Lieutenant Dove. And Lieutenant Dove is going to be here to complete that chain. So if you look at the case law, and we do have some cases prepared if you need them. Where's the copies of those, please, Your Honor? This is not fungible evidence, and the case law is very clear, Your Honor, that chain, you don't have to call every single person that touched the evidence throughout the way, that it only needs to be established as much as is practicable, and I think we've done that in great detail. That's
a critical question. Is it fungible or non-fungible? Is a cell phone fungible or non-fungible?
If you look at the exterior, it's fungible. You can't tell one. iPhone 11 from any other one until you open it, okay? But is the phone that was found at Paul, is that the same phone? And that's why you have the chain. It was cracked open and they got the material from, they want Doug to analyze. It is, this is an iPhone 11, Your Honor. It's not Paul's.
And Your Honor, again.
Fungible or non-fungible?
I'd say that it's not fungible, Your Honor. And again, I think we've had, it's clearly not fungible, and there's been
Clearly not fungible. And you say clearly, what do you mean?
well,
Generally, when things are clear, then we don't have a debate.
fair enough. That's a good point. I strenuously object, Your Honor. I apologize. But anyway, Your Honor, you know, when you look at something like cell phone evidence and you look at the class of types of evidence that are clearly fungible, those two are I think, different in the manner in which they exist and the manner in which they are. And I'm not aware of any case that's ever held a cell phone as to be fungible. It is a, you know, it is a physical item. Additionally, this particular one, I'm sorry, John, what does that say? And additionally, this particular cell phone has a serial number and an IMEI that is specifically identifiable. The cell phones are not fungible. They are specific. They have specific identifying information like that. And so again, I think that given the weight of that and the weight of what we have established, we more than established the chain.
No, chain of custody. I'm sorry. These, I'm sorry, I apologize. Your Honor, I note on this chain of custody, there's no serial number, there's no IME number, there's nothing on these documents. I'd be happy to, it's State's Exhibit 298 and 299. There's nothing on these indicates. It says matter of fact, the description is Paul's cell phone. There's no identifying data on this whatsoever. And by the way, I think we've been sort of lax. We should have asked all these witnesses how they know it was this cell phone. They never testified to serial numbers. That's water over the dam, under the bridge. But perhaps I should have asked that.
Well, and again, Your Honor, these came in without objection associated with testimony about that specific phone that people like McManigal and Agent Van Houten have specifically identified as associated with these chain sheets and with that specific phone. So again, I think that's a specific identification and they are not fungible in that regard.
Again,
Cases that you said you have.
Your Honor, and I've got a copy right here. This isn't specifically, may I hand it up to Your Honor?
Yes. Tell me about the case. State
So, again,
v.
Your
Pulley.
Honor.
State v. Pulley, yes, sir.
All right, and again, this is just a general, this isn't related to cell phones in specific, but it does talk about, establishing the chain of custody as far as practicable. And again, it talks about where the evidence establishes the identity of those who have handled the evidence and reasonably demonstrates the manner of handling of the evidence, which we've had testimony as to both of those. Our courts have been willing to fill in gaps in the chain of custody due to an absent witness. Proof of the chain of custody need not negate all possibility of tampering so long as the chain of possession is complete. It goes on, Your Honor, and that, I apologize, that was from Head Notes 5, 4, 5, and 6. It goes on to talk about a perfect chain of custody is not required. I think the evidence here on the whole has been more than sufficient to establish the chain. And additionally, even beyond that, I think that none of that precludes Lieutenant Dove to testifying about, given the foundation that's been laid, to testifying about the contents of that extraction pending any additional witnesses that will come in. I don't think that's precluded at this time either. He can still go forward and testify as to the extent of his testimony about that extraction, and certainly understanding that any additional witnesses are still forthcoming. So I don't think that precludes him from testifying as to the contents of that extraction.
Your Honor, with all due respect to the Attorney General, the footnote says when establishing Head Note 4, when establishing chain of custody of fungible, bolded evidence where multiple people have handled or analyzed the substance, the identity of the individuals who acquired the evidence and what was done with the evidence between the taking and the analysis must not be left to conjecture. And there's nothing in any document we've heard or any witness that is specifically identified that I got cell phone M4381 and gave it to somebody else who says, I got that same cell phone because it had the same serial number. I mean, if that's not conjecture, I don't know what is. And again, what's the big hurdle here? He's got 3 people he needs to call. Unless there's a problem with one of them, that has signed this document that didn't have it. And I think that this is an important piece of evidence. And we ought to just require what's required by this case and every other case where there's a fungible item.
Your Honor, again, going back to headnotes 4 and 5, testimony from each custodian of fungible evidence, however, is not a prerequisite to establishing a chain of custody. Again, we've had testimony about collection, we've had testimony about the manner of collection, and we've had testimony from those who actually analyzed it in the interim to get to Lieutenant Dove, who will then complete that analysis. So we've got testimony about collection, we've got chain sheets supporting that, and then we'll have every person who actually analyzed it. And I think that's more than sufficient chain to establish its admissibility at this time.
Anything further? Last word.
Nothing from the state, Your Honor.
Nothing from the defense.
All right. To the extent that this is a motion to exclude this testimony, the motion is denied. I do not believe that the portion of this case that State v. Pulley that says the identity of individuals who acquired the evidence and what was done with the evidence between the taking and the analysis must not be left to conjecture. I believe that a cell phone is not a fungible item, but it is complicated to the degree that there was analysis done with the cell phone, but the testimony, particularly the testimony of Van Houten, sufficiently establishes that this phone was not tampered with, could not be tampered with, and I believe that the state has sufficiently established a chain. Cases have held that a perfect chain is not necessary, and I believe the state has sufficiently established the chain of custody to the degree necessary that the next witness can testify. So I deny the motion, and the objection is noted for the record.
Thank you. Your Honor, make sure the record is complete. All due respect, we accept her from your rule.
I said it's noted for the record, yes.
From the old school, I'm sorry.
Yes, sir. Bring the jury.
Your Honor, to be clear, we do have one interim witness before that witness will testify.
Dad, we got this.
We got this.
Come check out town.
We got this. We got this.
Life is for living.
We got this.
Let's partner for all of it. Edward Jones.
A mother and son found dead, millions of dollars in missing money, and
Thank
the
you.
downfall
The
of a
next
family
witness.
dynasty.
Thank
The
you, Your Honor.
saga
State
of the
recall,
Murdaugh
John
family attracted
Bedingfield.
national attention after disbarred South Carolina lawyer Alec Murdaugh was accused of killing his wife and son.
Every day almost since the homicides, something new has happened, and I think that's just captivating to people.
Murdaugh was charged with 2 counts of murder in July 2022 after his wife Maggie and son Paul were found fatally shot a year earlier at the family's hunting estate. He's pleaded not guilty to the charges and will face trial in Colleton County, South Carolina. Here's what you need to know about the case against Alec Murdaugh. The first stage of the trial is jury selection, but because of the prominent family name, selecting 12 jurors that
John
aren't
Bedingfield,
familiar with the Murdaugh
B.E.D.,
family or the case will be a
INGFIELD.
challenge.
Jury selection is just going to be incredibly
Doing good.
tough. Everybody knows the
Tell us where you live.
That's because
Barnwell.
the legacy and legal influence of
Tell
the
us a little bit
Murdaugh
about
family
yourself.
in
You grew up
southeastern
there, or-
South Carolina
Grew up
dates
there,
back
born and
to
raised
the
in
early
Barnwell.
1900s. The family established one of the state's
Worked there
dominant
my
law
entire
firms
career,
in
of
1910,
28
and
years
three
with the Department of
generations of
Natural
Murdaughs
Resources.
have presided as
Still live in
solicitors
Barnwell.
over the
Where do
14th
you work
Judicial
now?
Circuit, which covers 5
I'm the
counties
Region
in
3
South
captain,
Carolina.
which is the Midlands region.
from
Lake Murray,
1920
Lake Marion.
when the first Murdaugh ran for office
And is that law
until
enforcement position?
2006
Are you a
they
class
knew
one
every
officer?
law enforcement
I am.
officer
And you said
in
you've
their
been with
region.
DNR how
The
long?
local
28
agencies
years.
that
Has
first
that been
arrived
the
at the
extent
crime
of your law
scene
enforcement career?
recused
Yes, sir.
themselves from the case because
Are
of
you
the
still
family's
employed
close
there?
ties
Yes, sir.
to law enforcement.
Do you have
That's
any
pretty
other
serious
businesses or
reputation.
any
Even
other
now,
economic
even
stuff
with
you're
Elk Murdaugh in
associated
jail
with?
for
I do.
more
Back
than
in
a year,
2016,
people are still intimidated.
I got
by
a federal
this
firearms
family
license
because
to
they've known
sell
their whole
and
life.
manufacture firearms.
And tell me how you got into that. What led you to develop that? Is that like a side business?
Side business is just a
While
passion I had
investigating the
of,
double
of
homicide,
working
law
on guns
enforcement
and
discovered evidence of a
building
string
guns,
of
decided
alleged
to turn it into
financial
business.
crimes.
All right. And
He
you
was a
mentioned
personal injury
federal
lawyer.
firearms
His
license. Is that what
clients
people
were
know as an
some of the
FFL?
poorest
Yes.
of the poor
All right, just
and
tell
the
me
most
very
badly
quickly what it
injured.
takes-
And he's
what does it mean to have an
accused of
FFL?
siphoning money
It means
off
you can-
of judgments
can-
that he won on behalf of